Thank you. Good evening. This is fantastic that we have a turnout like this because we get calls every day in the Sheriff's Office on questions on license to carry firearms. Well, we're going to talk about how to get a license to carry a firearm. We're going to talk a little bit about what you can do and can't do with that and some of the other things relating to firearms. So, the right of the citizens to bear arms in defense of themselves and the state shall not be questioned. That's in the Pennsylvania Constitution. We have a right to have firearms, to bear arms, to protect ourselves and our property. The Pennsylvania Uniform Firearms Act of 1995, which is in the Crimes Code, went into effect in October of 1995. It provides uniform rules for an entire state. And it says mostly there. Not long ago, several years ago, it was a little bit different in Philadelphia. You couldn't carry a firearm on the streets of Philadelphia whether you had a permit or not. Now you can. There's actually a section in the Crimes Code that says you can as long as you have a permit. It defines what types of weapons require licenses and the types of licenses available. And it's not the exclusive source for law for carrying a weapon. There's federal laws and there's other things also. Firearms that require a license. A pistol or a revolver with a barrel less than 15 inches. A shotgun with a barrel less than 18 inches, or a rifle with a barrel less than 16 inches, or any firearm with an overall length less than 26 inches. Now keep in mind, there's another section in the Crimes Code that specifically talks actually about shotguns. If you have a shotgun with a barrel length less than 18 inches, it could very well be considered a prohibited offensive weapon. So don't think you can strap on a little short shotgun and go walk in the streets, because that's not the case. Loaded, the definition of loaded, ammunition in the chamber, or if there's a detachable magazine, if the magazine is in the firearm, it's considered loaded. If it was unloaded, it would be separate and not next to the gun. It is a crime to carry a firearm without a license under the following circumstances. In your vehicle, concealed on or about your person. That's specifically what the license to carry is for. To carry hidden on your body or in your vehicle. You do not need a license for a firearm in your house, at your fixed place of business. That doesn't mean if you're a salesman and you're traveling, you can't have a gun unless you have a license in your vehicle. If your fixed place of business in one location, you can have a firearm there to protect your business, your property, or whatever. Also not concealed on your person. It does talk a little bit about open carry. While legal, generally not really a good idea. If you carry a gun openly, like you see police officers in uniform is an example of someone carrying a gun openly. That creates all kinds of issues. It makes you a target, and it's not safe. You're bringing a gun into a situation that you know, police officers, when they carry guns like that, they receive a lot of training on how to retain that firearm. If someone tries to take it away from them, they know how to defend that. Generally, citizens don't have that training. So, it's legal, but I'm suggesting that you don't do it. It's just not a good idea. If questioned by a police officer, you may need to provide ID. You don't have to show ID, but you're probably going to be talking to an officer. If he sees you walking down the street openly carrying a gun, he's going to draw your attention. You may get in a discussion with him. You don't have to stop and talk to him. It's just a mere encounter, like any other citizen you might walk up to in the street and talk to. But as law enforcement, it's our job to try and protect the public. And if we see someone openly carrying, you don't see that every day on the streets in Berwick. So you're probably going to draw some attention to yourself. Keep in mind, though, if you're open carrying, as soon as you get into a vehicle, if you don't have a license to carry a concealed firearm, you're breaking the law. Okay? Just want to be clear on that. There is some confusion there. There's no such crime as brandishing a firearm in Pennsylvania. You can do it, but be careful. If you do it in a threatening way or you point the gun at someone, now you're going to have problems. Other license exceptions. Law enforcement officers, not just while on duty, and military personnel while they're on duty. It goes on to say also wardens, constables, and their deputies are exempt, whether they're on duty or off duty. While hunting, fur taking, or fishing. While hunting, fur taking, or fishing, number one, you must follow the game laws and have a hunting license or another type of license that allows you to carry the firearm. Also, if your license expired within the previous 6 months, 5 years is a long time to remember. We do send out notices at least 60 days before your permit's going to expire. That doesn't relieve any way of any responsibility other than you. If your permit expires, you're responsible. But the law does give you a 6-month leeway. So if you forget about it, 3 months after it expires, you say, oh geez, my permit expired, you still have some time to renew it. When transporting a firearm for purchase, sale, repair, or moving, provided it is not loaded. You can transport a firearm if you don't have a license to carry concealed in a vehicle, but it must be unloaded. The gun must be in one location, in storage. You don't want it sitting on the seat next to you. And the ammunition in a separate container, somewhere else in the vehicle. Don't have them together. How to obtain a license. Complete an application and submit it to the sheriff's office in the county in which you live. I know in Berwick, some of you may live in Salem Township. Salem Township is in Luzerne County. Unfortunately, you have to go to Wilkes-Barre. You can't come to Columbia County for that. Columbia County requires a 2-sided form. The fee is $20, payable when you submit the application. We do a background check for every application we get, whether it's a new application or a renewal, which consists of a PICS check, which is a Pennsylvania Instant Check System. That checks databases such as criminal history, mental health records, the Protection from Abuse database, juvenile records, just to make sure there's no issues in someone's past. The permit must be picked up in person. We take your picture in the sheriff's office now. It's something we started about 2 years ago, which is, it's a really nice system. It gives you like a driver's license type permit now instead of the old paper that we used to laminate. It's a crime to provide false information on your application. I mean, you sign it that you are truthful and told us everything we need to know. Those who cannot get a license, convicted felons, persons declared incapacitated or involuntarily committed to a mental institution. 3 DUIs in 5 years, fugitive from justice, the Protection from Abuse Act, which I mentioned a minute ago, illegal aliens, and other enumerated offenses. Those enumerated offenses are on the back of the application. You can also get them on the web, sheriffofcolumbiacounty.com. Print them off, fill them out, and send them in. Also, when we do the backgrounds, I forgot this, on the new applications, we require 2 references. Some counties don't check those references. We do. We talk to every one of them. And when you submit the application, we ask that you ask your references to call us. Because in January of this year, we did just shy of 500 applications in 1 month. And I think that was a little bit because of politics, a little bit because of the shooting in Connecticut. So you can imagine if we have 500 applications, if 350 of those were new applications, we got 700 people to talk to. Because those applications each require 2 references. So we ask that they call us so we don't have someone sitting there all day making phone calls. They're trying to get people when they're not home. Obligations to law enforcement. When carrying a firearm concealed on or about one's person or in a vehicle, an individual licensed to carry a firearm shall, upon the demand of a lawful enforcement officer, produce the license for inspection. Failure to produce such a license, either at the time of arrest or at the preliminary hearing, shall create a rebuttal presumption of non-licensure. We would just assume you don't have one. Carry your license with you at all times if you have a gun with you. Where you cannot carry, a post office, it's federal property, the courthouse, there are lock boxes at the front door of the courthouse. You can lock up your gun, or you can bring it to the sheriff's office. We'll put it on a shelf and hold it for you while you're there. State parks. State parks, there's not a general law that covers state parks. Most of them are different. Some will allow it, some won't. If you're going to go to a state park, call ahead or go on the web. I'm sure you can find the information. Obviously, if you have a license and they allow firearms, you can carry one there. Private property. I'm sure you all remember this year with the fair. They considered not allowing guns on the fairgrounds. The fairgrounds is private property. It's owned by the shareholders. If they say we don't want firearms, no firearms. Carrying on school property. Gun-free school zones do not prohibit a properly licensed person from carrying on school property. However, state law says you cannot carry weapons on school property. And it goes on to say, well, on buildings, grounds, or transportation to or from. That means if you put your child in a car to take him to school, you have a gun in a car, it's against the law. Transportation to or from. And in a rural county like this, I know a lot of parents, and I talked to some after our first seminar we did in October. They say, gee, I go hunting, I don't want to drop my child off on the way out to the woods. I have my gun in the car. It's against the law. You can't have your gun in a car. The defense to it is other lawful purposes. Maybe some school event. I know Berwick has a rifle club. But outside of those exemptions, can't do it. Bloomsburg University. This question came up in our last seminar. Bloomsburg University, you can carry a gun on campus concealed with a license to carry a firearm. However, there are some buildings that are off limits. Some of the educational buildings and some of the events that they have at the college. State game lands, we talked about. Rails to trails, it varies by where you are. National parks, the law of the state in which the park is located. But still, call ahead if you're talking about a park, because some allow for it and some don't. Reciprocity. These states, and I'm not going to read through them, but they all recognize our permit. So if you travel to those states, the problem, and you see here with the map, other than West Virginia, nobody around us recognizes our permit. You know, like New York, obviously, they got tough gun laws in New York. Same with New Jersey. So, yeah, all those blue states recognize our permit. Like I said, now you can travel to those states. To get to those states, if you're going through a state that doesn't recognize our permit, unload the gun, put it in the trunk or in storage, the back of your vehicle somewhere, unloaded, with the ammunition in a separate container, transport it through that state. When you get to a state that recognizes our permit, get it back out, load it up, put it in your pocket if you want to. You'll have no problem.
The law of self-defense as it relates to deadly force. Those of you who have carry permits know that when you made your application, you have to state the reason why you want the permit. And I haven't specifically asked him, but I bet if I did, he would say that the majority of the reasons that are stated are self-protection. So, you've got a license to carry a firearm for self-protection, and you've just had to use it. Now what do you do? And that gets us into the law of self-defense as it relates to deadly force. Self-defense in Pennsylvania is what's called a justification defense. It's what takes what would otherwise be the crime of criminal homicide into not being a crime at all. And it's absolutely positively driven by the specific circumstances of the situation. Now, historically, Pennsylvania recognized the law of self-defense. It had some well-established rules that had evolved over the years and were recognized by decisions of the various appellate courts. But in 2011, the legislature stepped in and made some significant modifications to the law of self-defense. And in a couple significant ways, it broadened the right to use deadly force in self-defense. And we're going to talk about those. Traditionally, the law of self-defense said that if you were to use deadly force to defend yourself, you had to be actually confronted by a deadly force situation. You had to have someone who was in a position to exert deadly force against you, either with a weapon of some kind or in some circumstances with enough difference in size and strength and circumstances showing an immediate threat that it could be demonstrated that there was this risk of deadly force causing you serious bodily harm or death. The legislature stepped in and said, we're going to specify certain circumstances that will justify the use of deadly force. And there are two specific criteria that must now be proven under that law. The first is that the force is immediately necessary to protect oneself or another person against death, serious bodily injury, kidnapping, or sexual intercourse compelled by force or threat. The second requirement is
that the person who's claiming the justification of self-defense must not have provoked the incident, must not have, for example, pointed a gun at their enemy, hoping the enemy would pull out a gun of his own so they could have an excuse to shoot him. Now again, these are all circumstance-driven, and it's all going to be largely determined by police investigation into the circumstances, with the decision ultimately made by the district attorney as to whether or not a self-defense defense applies as a justification in the event of a death. So the legislation clarified Pennsylvania law and set up these two specific criteria which must be applicable to a justification defense of self-defense. There's a second thing that the law did. It set up certain presumptions. And part of this relates to what's referred to
as the Castle Doctrine, which we'll be talking about in greater detail. But historically in Pennsylvania, if you were in your home and you perceived a threat of deadly force against you, someone entered your home with a weapon with apparent intent to do you harm, you had the right to exercise deadly force in defense of yourself, your loved ones. That same doctrine applied in your place of business. If someone entered with apparent intent to do you harm, you could exercise deadly force in self-defense to protect you, your business, and whoever else was there, and you did not have any obligation to retreat from that threat. We'll talk more about that as well. The new law set up certain criteria that broadened the circumstances of what's considered a threat of deadly harm. And it specifies that you can presume that there's an imminent use of force necessary to protect yourself when two specific circumstances coexist. The first is there's a person entering or has entered or is attempting to remove a person from your residence or your occupied vehicle, and that unlawful or forceful entry has already occurred or is occurring. In other words, if you're in your house and someone breaks in the door, you don't have to see a gun, you don't have to see a knife, you don't have to see a specific imminent threat. There is a presumption that works in your favor that that unwarranted intrusion is a threat. Traditionally in the past, and everybody's heard the story over the years from the cop who's the friend of the family or the sheriff who's the friend of the family, you know, somebody comes to your door and makes a threat. If you have to shoot him, drag him inside. We've all heard that. Well, nowadays, by their coming inside, they are perceivable as an imminent threat, and deadly force may be exercised in self-defense. That's the first significant broadening of the self-defense justification. And that's part of the Castle Doctrine, as I mentioned. The second part of the Castle Doctrine has to do with something that's commonly referred to as the duty to retreat, the flip side of which is stand your ground. And I'm sure most of us saw or read or heard about the case in Florida, the Trayvon Martin case, and that case was based on the principle of stand your ground. The 2011 law that Pennsylvania adopted followed about 14 or 15 other states, including Florida, in implementing this provision that modified the historic duty to retreat. As I mentioned before, historically, if you were not in your home, not in your place of business, if you were out in public somewhere, if you were confronted by a deadly force threat, if you had an apparent avenue of safe retreat, you had to take it rather than responding with deadly force. And if you didn't exercise that duty of retreat, you could be prosecuted for killing the person who was the threat. Certainly didn't seem very fair, didn't seem right, but that's how it was. Now that has changed. The duty to retreat doesn't apply in certain specific circumstances, and they're listed here. If you have a right to be where you are, you're in a public place or a private place where you have the right to be. You're not engaged in any criminal activity of any kind, related to force or otherwise. You are in legal possession of a firearm. That means Either it's a circumstance where a permit is not required and you have it, or you have a permit and you have a firearm. You have the right to use deadly force and there's a firearm, replica, or other lethal weapon displayed. Now, here's what that means. If you see a weapon of any kind, an apparent weapon of any kind, displayed in a manner that is threatening to you in a public place, you're lawfully there, you're armed, you do not have to retreat. You may immediately respond to that threat with deadly force of your own. And that is a significant change in Pennsylvania law. It changed a couple hundred years worth of Pennsylvania law. And that's exactly what the circumstances were in the Trayvon Martin case. And that person, Mr. Zimmerman, relied on his right to stand his ground to what he described as a threat, what the jury apparently perceived was a threat sufficient to justify his use of force in that case. So, long story short, you've now got a permit to carry a gun. Everything that Sheriff Chamberlain said is of critical importance. You have to follow the law in order to invoke the right to use that firearm in self-defense. You have to have it lawfully in your possession. You have to use it in a manner in accordance with the law. You have to react appropriately to the threat or the threat circumstances that exist. If you're not in your home where the presumption applies, there has to be a specific identifiable threat that causes you to react. If you do those things, you should be safe from prosecution, even if it's necessary to take a life. You know, use of force is always, hopefully, the last resort to resolve any dispute, to resolve any situation. You know, we always hate to see a life taken unnecessarily, but if it's a case of legitimate self-defense, then it's not unnecessarily. If there's an actual threat, a reasonably perceived threat, and the response to it is in accordance with the law and is appropriate under the circumstances, then that's a justified response and there's no crime. So, that's the law of self-defense as it relates to use of deadly force. And I think we're ready for questions.
When you were talking about the law about in a vehicle,
Yes.
I believe the wording of it says if it's somebody's attempting to present or attempting to enter your vehicle.
Yes.
And there's sometimes now where I drive through Philadelphia, I carry. Now, what if somebody would come up to the, like you're sitting sometimes at a traffic light or something, and somebody comes up to the car window, they're not trying to get in, but they may have a gun or a knife or something.
Well,
How would you find it?
if they have a gun or knife on display, and it's in a manner that's menacing, and the reason I say it like that, as Tim said, you know, there are some people, well, not some people, there are people who are permitted to, choice of words. It is not a crime to openly carry under some circumstances. I certainly endorse his view that it's not advisable in most circumstances. It's rife with problems. But if you do, merely having it on your holster or on your hip is not a threatening action. So if someone walks up to your car with a pistol on his hip and a squeegee in his hand and says, "Hey, mister, can I wash your windshield?" No, that's not a threat. If he just walks up and taps on your window, no, that's not a threat. He may be asking for directions. If he walks up to your car, taps on the window, and puts his hand on the butt of that pistol, yeah, I would say, damn right, that's a threat.
But he's not trying to
No. The key says it's an entry or an attempt to enter. So unless there's an actual attempt to get into the car, a carjacking, whether it's to try to pull the door, whether it's to try to force a window, unless there's an attempted entry, then it's not the automatic justification. It might still prove to be justified without relying on the presumption of threatening circumstances based on the specifics of the action. What did he say? Did he have his hand on the pistol?
The interest of another person, you're in a public parking lot, you see somebody being forced into a car or somebody's purse being stolen. It's not yourself that's you're defending, but you're assisting another person.
The short answer is no. And the reason for that is, it's a two-word phrase, self-defense. Self-circle applies to those with you in your immediate circumstances, in your car, in your home, but out in the public park, no, that's what the police are for.
You can carry any place in the state of Pennsylvania, any city. Like you
Yes,
said, Philadelphia you can, which I thought you couldn't. Pittsburgh you can.
yes.
How about New York State and New York City?
No. New York does not recognize our permit.
Okay.
No. The permit that you get in Columbia County, he asked where you could carry it, in any city. The permit is good for Pennsylvania, any city of Pennsylvania, and those states that recognize our permits. Go ahead.
If you carry concealed and you're pulled over for a traffic violation, what's your duty to let the officer know that you have a license?
Yeah, if you're pulled over and have a gun in the car, what are your duties? You're not required to reveal that you have a gun. However, I'll caution you that if the gun is in a place, like in your glove box, and you're going to go in there to get your registration and your insurance, before you enter that compartment, say something to the officer. Because if you go rooting through there and it falls out on the floor, you're probably going to be looking at the end of his gun. So,
Tim, there are some states that do require to notify the officer if you are stopped.
okay.
You have a firearm in
Yeah.
the car.
That's not
License as
Pennsylvania,
well.
though. It is a good idea, but you're not required to.
Do you have to do anything special if you're going to transfer a gun from a father to a daughter?
No.
The question was, do you have to do anything special if you're going to transfer a gun from father to daughter?
No, you don't have to. Lineage, from what I've been told by dealers, this is a good question for a dealer. Lineage down, parent to a child, no, you don't have to.
Or grandchild.
Right, right.
Limited to the inside of your house, or is it your property in general?
The question was, is the castle doctrine limited to the inside of your house or your property in general? And the short answer is, since the statute was adopted, it's your house or your car, your dwelling or your occupied vehicle. And the reason for that is that those are confined areas where you're in there, escape is not readily available. If you're out in your backyard and someone comes in through the side fence, if you could head out the back gate, do it. But it's at least as far as the presumption goes. Remember, there are two different aspects to this. The law set up a presumption that loosens the circumstances where you can use deadly force within your house or within your vehicle. You don't have to prove that this intruder was actually armed with a deadly weapon. There's a presumption that they intend to do you deadly harm just from their forced entry. If you're in your backyard and you happen to have a weapon on you, and somebody comes through your front gate with a knife, then I would say that threat is imminent, it's present, you could go ahead and use deadly force in self-defense if it was necessary. You couldn't invoke that presumption still in the law because you're not inside the building. But under all those circumstances, and it's going to get into how close he was, was he running toward you, was he walking toward you, did he say anything threatening, or did he say, hey, I found this knife out on the sidewalk in front of your house, is it yours? These things are all driven by circumstances when you're outside the presumptions that the law sets out. So where you are, where he is, how fast he's moving, what he says, what he's carrying are all going to factor into a situation outside the presumptions. Backyard, that kind of thing.
If I'm traveling from Pennsylvania to Florida, and a member of my family is driving with me and sharing the driving responsibility, she does not have a permit to carry, I do. She gets pulled over for some reason while she's driving. Is there anything special I have to do, or can she get in trouble, or?
No, you're in the vehicle, right?
Yeah.
You have a permit. The question was, if her and her friend are driving to Florida, and she has a permit to carry a firearm, there's a firearm in the vehicle, but her friend, who takes turns driving, does not have a permit, does she get in trouble? No. because the permit holder is in the vehicle with the weapon.
When it comes to entering a bank or a bank property, is it allowed to carry a firearm? Whether you're pulling your car up, you know, to a drive-through or carrying it.
The question was whether or not you're permitted to carry a gun on bank property, whether in a car, in a drive-in, or a walk-in to the lobby.
There isn't anything in the Uniform Firearms Act that says no. Any license to carry that says no.
Say I'm away, my friend's there watching my house, you know, taking care of my pet, and somebody breaks in while they're there, do they have the right to defend themselves inside my home if I'm not home?
Yes, they're an occupant of the dwelling.
Okay.
The question was, does a guest in the home have the right to exercise self-defense while they're in the home? In this case, a house sitter, and the answer would be yes. They are a permitted occupant of the dwelling.
My question is, you were talking about if you pass a weapon down to a son or a daughter, do they have to register that weapon?
No.
And what if they have felonies? You know, you gotta, or if, let's say you pass it down and they use it, and the first thing when the police get that, they call it right back to you.
Well, the question is if you pass a gun down and you pass it to a son or a grandson, and they have a felony, who's responsible? You have to register it, and that, Mr. DA?
I mean, if you're passing a
The short answer is, depends. Because not all weapons have to be registered. If it's a weapon that has to be registered, if the person doesn't qualify for registration, then it's not a valid transfer.
Okay,
If it's
well,
a weapon
what
that does have to be transferred and they do qualify, fine.
What weapons have to be registered?
Handguns, excuse me. Handguns do. I'm not sure, I know that, I shouldn't say I know, I believe there are differential regulations about firearms.
Yeah.
Those are federal requirements, which I don't generally deal with, so I'm not privy to the specifics, but it's my belief that there are differential regulations based on different types of long guns in terms of registration.
Sir, I would suggest that it get transferred through a dealer, even though it's lineage down, because if you, say you will it to someone, or you hand it down before you pass, and now your son has it, it's stolen, it's not registered to him. So if you make a police report, it's much easier if it's registered to him. So it's a good idea to register it no matter what. Transfer it legally through a dealer.
You didn't hear it say something from a grandfather or pistol or something. I have a permit to carry a concealed weapon. Can I carry that weapon even though it's not registered?
Yes. Yes. If a gun was handed down from a father or a grandfather to a child, and he has a permit to carry a gun, can he carry that gun? Yeah. You don't have to transfer it lineage down, so if you legally have the gun, you can carry it. Way in the back, sir.
This time of year, everybody's spotlighting. Carry concealed or not concealed. I know it's game laws, fishing game laws apply. Is there anything that we can find on that? Do I have to have it in my trunk? I'm not allowed to have any firearms at all while I'm spotlighting deer. Can or can I?
That's a good question. I have seen Game Commission officers ask that question. They don't want to answer it. The permit, the license to carry a firearm allows you to carry a firearm concealed, a handgun, a gun of that nature. While you're spotlighting, as long as you have a license to carry a firearm, you can have that in your vehicle, loaded, on you or in your vehicle. Now, if you have a loaded rifle in your vehicle, that's different. Now, Game Commission is going to stop you and say, you're hunting, and they're going to cite you. And you're probably going to be found guilty.
Okay.
Because, you know, the requirements for a license to carry a firearm said a shotgun with a barrel length less than 18 inches, you know, an overall rifle less than 26 inches. You got a hunting rifle in there, that doesn't fall under that. Right. Now you have a hunting rifle, and you're probably going to cite it. But no, as long as you have a handgun, you're permitted to have that if you have a license to carry firearms concealed while you're spotlighting.
My wife doesn't have a carrying permit, but if I leave my gun in the glove box and she takes my car and she gets pulled over, what would happen?
Good question. If he has a gun, he leaves it in the car, his wife drives the car. My wife...
He has a permit, she doesn't.
Right, he has a permit, she doesn't. My wife got a permit for that very reason. So if I leave a gun in one of my vehicles, and she gets in it to go somewhere, she's covered. However, and I just saw this recently, there is a section in the Uniform Firearms Act that says, that covers that situation. If I leave a gun in the car, I have a license to carry, actually I'm exempt because I'm the sheriff, but if my wife gets in the vehicle, that's my gun, my car, she's okay.
With the options that you have, carry concealed, hunting, sporting, you have different options of your permit. Is that correct?
Yes. Yeah. The permit that the sheriff's office issues will cover you for hunting.
Okay, but there's 3 different options you can actually select on your application.
Yes. Yes.
Carry concealed, does that carry all of that? Does that carry sports if I
Yeah.
want to hunt?
Yeah, there's actually, on the system that we have now, there's a default, it goes right to self-protection. So your permits are going to say protection. But you're covered for all those things. You can mark one of those or any number of those options.
Along the lines of the employee, and a lot of employers prohibit people from having firearms on the property. Several states have enacted laws saying that if you are licensed to carry concealed, that an employer cannot prohibit you from having the firearm in your vehicle, provided you're properly licensed. Is that something that we are pursuing, or is that something that you would be interested in pursuing on our behalf?
Just today, delivered to my office, was the preemption, is what you're talking about. I haven't had a chance to look at it yet, but I certainly want to get a lot of background on it. We have a Second Amendment caucus in Harrisburg, and I'm going to run that by our caucus, and I promised the individual who dropped that off that would be my first step with it.
Yeah, I have a question about a homestead. Say you've got acreage around you and you're out in the field working. You have a weapon with you. You see someone go in the door. Now, I want to know if I can defend my house from the outside. Can I wait for them? I have the availability to get a gun from another building within a few seconds. Am I okay to defend myself when they come out? Because they're probably going to come out with more weaponry than they went in with. It worries me quite a bit, because we're all over the place, like, you know.
The short answer is, in terms of the presumption, if they've entered your home forcibly, which basically they would have done if they didn't have your permission to be in there, and they're in there, you can go in and defend yourself after entry. As far as waiting on the outside, depends on the circumstances. Because if there was nobody inside the house, if you're outside on a tractor and you're 50 yards away, your life's not in danger. They may be a thief, but there's no evidence at that point that they're there to do you physical harm. So then so you're not going to fall within that presumption that we talked about. Then it's going to be circumstance driven. What do they come out with? If they come out with a gun of yours, particularly if it's one that you know is kept loaded, even though you probably shouldn't do that, then you know they're in possession of a loaded weapon. And if you're between where they are and where they're going to want to go to leave your property, then it may be a threatening situation to you. But if you're just out there and you're just not happy that you've been robbed, no, that's not enough to justify use of self-defense. There's got to be specific evidence of a threat when you're outside and they're coming back out.
With that concealed permit, are you obligated to keep the gun concealed on you at all times? Can it accidentally be shown?
No, the license allows you to carry it concealed. In Pennsylvania, there's no law that says you can't openly carry.
Right.
So, yeah, if
And
someone sees it, no
assuming
problem.
it's safe on a semi-auto to have it chambered?
Excuse me?
Have it chambered, around chambered on a semi-automatic handgun?
Was your question, is that safe?
No, is that allowed?
Yeah.
If an intruder comes in your house, sees you have a gun, and he retreats, and you shoot him in the back.
The question was, if an intruder in your home sees that you have a gun and retreats, can you shoot him in the back? Once they start heading the other way, particularly if they're close to a door, the presumed threat from their forcible entry has evaporated. And if you shoot them in the back, you're the aggressor. and you and I are gonna have a problem. Yes?
Being small of stature, suppose he's already done me bodily harm, and then he's trying to get out of the house. I don't want him to leave the house after he's abused me to the point where I may not recover, and I can get to my gun. Can I shoot him in the back at that point? I have the scars to prove it by
Anywhere
then.
you can aim.
Pardon me?
Anywhere you can aim.
Assuming you had an incident at your house, say you had to dispatch, what is the procedure from there? You dial 911? tell
Call
the police?
911, notify them that there's an intruder in your home, that you're safe, but you shot the intruder, that you need the police, and you need medical personnel.
Okay, do you leave the home, leave the weapon outside? When the police come, do you know, what's the procedure? I mean, if you're
That's
standing
really
there.
more of a policing question. I guess from a legal standpoint, I would say you want to make sure the weapon is secure because you don't know that this person's dead. This person's down presumably.
Right.
But you don't want them to, you always see in the movies, you know, the person shoots somebody and then they get faint, they drop the gun within reach of the person's hand. Bad move. You make sure the gun's away from the intruder, preferably probably away from you, but close enough you can reach it if the intruder suddenly hops up. So the police get there.